to the Under Oath podcast with your host, Rich Lomurro. On Under Oath, you go inside America's most famous cases with the people who tried them. From O.J. Simpson's murder trial.
We, the jury, in the above entitled action, find the defendant Orenthal James Simpson not guilty of the crime of murder.
To the Deep Throat pornography case.
Deep Throat succeeded because the government went after it.
Our special guests take the stand and reveal their stories. Under Oath, live from the Courtroom at Lomurro Law in Freehold, New Jersey. Here is Rich Lomurro.
Hi everyone, welcome back to Under Oath. This episode, I need to give you a little bit of an intro because it was kind of all over the place, and that's because the guest on the show is just so remarkable and has so many really high-profile cases that we bounce around a lot, frankly. And we didn't even get to the case that I brought him on the show to discuss, which is the Bill Cosby trial. His name is Tom Mesereau, and you may remember him from the Michael Jackson child molestation trial. He tried that case successfully, defended Michael Jackson, got a full acquittal on all charges, felonies and misdemeanors. He represented Robert Blake, and most recently represented Bill Cosby. And that's I had him on the show to get to Bill Cosby, where we never got there in episode 1. He's gracefully agreed to come back onto the show, and that's when we'll go into the Bill Cosby case. But for this episode, we really focus on Michael Jackson, and we're going to go more into that in the next episode. But enjoy our discussion, part 1 of Tom Mesereau, a really remarkable lawyer, remarkable story, and an extremely charitable lawyer. He has a pro bono case, a capital murder pro bono case that he tries in Alabama or the Deep South every year on his own dime, which is remarkable. He also operates a legal clinic, a free legal clinic in Los Angeles for people who can't afford legal counsel. So imagine this, you go and get free legal counsel from one of the highest profile, most respectable lawyers on the planet, Tom Mesereau. So the guy's remarkable. He's a Jersey guy. Pumped to have him on the show. I know you're going to really enjoy it. Without further ado, here is part 1 with Tom Mesereau. Welcome to Under Oath. Our guest today is Tom Mesereau, and he's a Jersey guy, Jersey native from Englewood, New Jersey, and he represented most recently Bill Cosby. He's also represented Michael Jackson and Suge Knight and many, many other high-profile cases. We're going to go through Michael Jackson case, the Bill Cosby case, and then I'd like to highlight at the end your crusade to do pro bono work in Alabama and the Deep South, capital murder cases. Welcome to the show, Tom.
Well, thank you for having me. I appreciate it. Look forward to it.
So I have to ask you right off the bat, growing up in Englewood, New Jersey, you went to 4 or 5 different high schools.
Well, the first high school I went to was Loyola School, which was a Jesuit school in New York City, in Manhattan, at 83rd and Park. And I went there, finished my first year. My second year, I was kind of disgruntled, looking to make a change. I switched to Fordham Prep in the Bronx, which also was a Jesuit school. Was only there a couple of months and went back to Loyola. It was just a period of turmoil in my life. And then my third year at Loyola, I was suspended 3 times for disciplinary problems. I left Loyola School after junior year, went to Bergen Catholic High School in Oradell, New Jersey, high school where the Irish Christian Brothers run the school and teach. Fabulous school. And then I spent an extra year at Phillips Academy, Andover, in Andover, Massachusetts. I spent a postgraduate year because I'd had so many problems my first 3 years.
It's just an interesting path for someone who ends up at Harvard. I would wager to say that most people who go to Harvard didn't attend 4 or 5 high schools. And I'm glad you landed on your feet at Bergen Catholic, where I have tons of friends who've been there and speak so highly of it. I know they have a strong alumni basis, but that seems to be where you matured and where you found your way.
Well, you know, Loyola's a great school. Bergen's a great school. These are all fabulous schools with great faculties, great direction. I just was kind of a confused, troubled young person. I I accept all the responsibility for it.
So you were the first 16-year-old to ever be a rebel, I guess.
Well, I mean, I don't know if everybody goes to that many high schools, but let me tell you this. When I was at Andover, I interviewed with the director of admissions at Harvard, who came to Andover to talk to applicants. And I decided to be extremely open and honest with him.
Really?
I explained in detail that I had disciplinary problems in grammar school. I went to St. Cecilia's Grammar School in Englewood, New Jersey. My parents sent me to a small school, Loyola School, because they thought I needed a smaller class and more attention, et cetera. And I went through blow by blow everything that happened. And he then wrote a letter to my parents saying he hoped I went to Harvard. And they were in shock because I think a year earlier they didn't think the Marines would take me.
Wow, that's an interesting story. Hey, you found your way. You did land on your feet. You found your way into Harvard, and then you went and studied abroad for a year, and then you ended up in San Francisco for law school, correct?
Well, I graduated from Harvard. I worked on Capitol Hill for a year for a United States congressman from Staten Island. His name was Jack Murphy. He was a West Point friend of my father. My father was a West Point graduate. My uncle was a West Point graduate. I was born at West Point. My grandfather was an honorary member of the West Point class in 1915, which was President Eisenhower's class.
Right.
And we lived not far from West Point. So I got a job with a West Point graduate who was a congressman. I wrote his speeches, and I worked for one of his committees on the House side. And then went to London School of Economics in London for a year. It was a one-year master's program, got a master's degree. And then basically started law school. Wasn't sure if I really wanted to be a lawyer, but I finished law school and obviously became one. But my father, who did not go to law school, had always said, if you don't know what you want to do, consider law school. It opens many doors. And he always told me there is no more flexible degree than a law degree. You can do so many things with it. And he was absolutely correct, and I'll always be so grateful for his advice. But I didn't know if I really wanted to be a lawyer or what kind of a lawyer when I entered law school. But he was correct. So I've tried different kinds of law. I was with a big civil litigation firm in Washington, D.C. I was a DA for about a year. I worked for a company for a couple of years. I tried a lot of things and finally realized the courtroom was where I belonged. And I like fighting, against odds. I like defending the underdog. I don't like arrogance and elitism, especially when it's misused in the criminal justice system. And it took me a little while to focus on where my passion would be, but I found it because a law degree let me try different options.
Sure. And that's one of the nice things about our career is that there's different paths you can go. There's transactional attorneys and there's trial lawyers and many other ways. But you sit in the same seat that I do, which we're trial lawyers, and we enter the arena and argue cases in front of juries. It seems to me from doing some research that the way you got into, I guess I would call celebrity practice, was not by filling a room with celebrities and finding your way to crack into that crowd, but you actually found your way in through your pro bono practice and helping the needy. Is that true?
That's very true. Now, I had represented a few celebrities in my practice with, fairly minor cases, drunk driving, that kind of thing. And then I was asked by an Arizona lawyer who represented boxer Mike Tyson, would I be willing to be California counsel in an investigation by the San Bernardino County, California District Attorney's Office into whether he had raped someone. This was after he had been to prison for rape. And I said I would, and we did a bang-up investigation and prepared a booklet to explain to the DA why he should not be charged. And it had all sorts of background checks on the accuser and all sorts of forensic analysis of why it couldn't have happened the way she said it did. And to make a long story short, they decided not to charge him. So I would say he was the first major celebrity I represented in a context like that. Now, I had defended a celebrity in Los Angeles, a famous newscaster named Larry Carroll, who was an institution in Los Angeles. He didn't have the national presence that a Mike Tyson had. 20 years ago in 1998, he was indicted for securities fraud in a neighboring county. I did defend him. It was a 12-week jury trial, and just as it was going to the jury, the judge dismissed it in the interest of justice.
Unilaterally.
Yeah, that got some local notoriety, but Mike was the first national celebrity I think I ever really helped out. And with respect to the pro bono work, what gave me a national reputation was the Robert Blake case. Mm-hmm. And I got into that case in an interesting way. I, for many years, would donate my time to the first African Methodist Episcopal Church free legal clinic in South Central Los Angeles. Fame, we call the church, was probably the most preeminent African American church in LA, and they had this free clinic where 2 Sunday mornings a month, lawyers and law students and paralegals would help disadvantaged people. So one of the lawyers I would work with turned out to be a transactional lawyer for Robert Blake, and one day he told me that Robert Blake was looking for new criminal defense counsel. Would I like to meet him? And I said, sure. And I met him, and one thing led to another. But that's how I ended up defending Robert Blake in what was then the highest profile murder case in the country.
Sure. And the Robert Blake case, somewhat, I guess almost directly, fell right into the Michael Jackson case, right?
Well, what happened was I'm defending Robert Blake. The preliminary hearing in the case was coming up, and to anyone who doesn't know, in a felony case in California, there is always a preliminary hearing unless the felony was charged by way of grand jury indictment. If a grand jury didn't indict, if the DA's office files a criminal complaint, the defense always has the right to a preliminary hearing. And a preliminary hearing is an evidentiary hearing in front of a judge, not a jury, where the prosecution has to put forth enough evidence to convince a judge that there is a reasonable probability that a crime occurred. It's also called probable cause. Right. Very low standard. The defense, if they cross-examine, don't typically cross-examine that much for 2 reasons. One, it's an early stage of a case, and usually the defense is not prepared to do that. And secondly, even if the defense were prepared, they don't want to do it because they don't want to give away their cross that they might use at a trial. So the Blake preliminary hearing was coming up, and I made a very sort of unconventional choice, and that is that I was just going to rip into them at a preliminary hearing like I was conducting a trial.
Showing your cards.
I just sensed that the prosecution were feeling no pain. Mm-hmm. I sensed what I call hubris. They were very enamored with their case. They seemed to think that there's no way in the world they could lose it. And what had happened was, the Los Angeles County District Attorney's Office had been thoroughly embarrassed in the O.J. Simpson case.
Yeah, sure.
And they felt they filed the case too quickly before all their investigation and forensic work was done. So when they began to investigate Robert Blake, rather than file quickly, they waited about a year and did the most extensive investigation in a homicide case they'd ever done, far more so than the O.J. Simpson case. So when they charged Robert Blake, they felt they had really dotted all their I's and crossed their T's. And I just could tell that these very excellent prosecutors were very full of themselves and very full of their case. So I said to myself, they're going to call a lot of witnesses they probably don't have to call because they wanted to show the world what a great case they have, and I'm going to cross-examine them like it's a trial, pin them down on videotape, and I'm just going to take a chance that we can achieve some good out of this.
Now, let me ask you a question, Tom. I mean, in suppression motions in New Jersey, a lot of times we'll want the cop or somebody to take the stand just so we get a crack at him before trial. Is that kind of the same deal out there for those preliminary hearings, or is it not the same kind of free crack at a witness? Usually people don't take, because it seems like what's the downside of doing what you did?
Well, the downside, as I said before, is if you're prepared to cross-examine live witnesses, you telegraph your cross-examination.
Right.
So the prosecution, well in advance of trial, can say, look, here's what he's going to do. How do we handle this? Here's what he's going to say. How do we neutralize it? Blah, blah, blah. But in this particular case, Robert Blake was charged with murder with special circumstances, which is a form of homicide case which could bring the death penalty. And Murder with special circumstances is a case where typically the defendant does not get any bail. There had been one case in California where the prosecution and the defense had stipulated to a bail amount in a murder with special circumstances case, but nobody had ever gotten bail in this kind of a case in California over prosecution objection. So we came up with some novel arguments why bail should apply that were pretty unique. But I also had a feeling that if I just, annihilate their witnesses and just devastate their case, maybe we can convince the judge that bail is appropriate. And that's exactly what happened.
Wow.
Nobody thought we could possibly get bail, and Mr. Blake got bail. Plus, their case, in my opinion, was just devastated at a prelim. All their main witnesses. By the way, I forgot to mention, in California, you can bring in hearsay evidence at a prelim that you can't bring into a trial. In other words, the investigating detective can talk about what witnesses will say in a way that investigative detective can't do it at a trial. But they were just putting their live witnesses on, and I just got a crack at all of them. They're experts. They're experts on gunshot residue. They're forensic people.
So they didn't have to. They did not have to give you all that ammo. They could have just gotten everything. Oh, that's interesting.
And I got in the case late. I replaced someone, so I talked to one of the prosecutors since then on a number of occasions, and he said, "We never thought you could be that prepared, and we never thought you would do what you did."
Wow.
So it really, so many good things came out of the prelim. Blake got bail, which, no lawyer had ever told him you could get bail in a case like this. I told him that, anything's possible in a criminal case, but, and I was going to go for it. So he got bail. Their case was decimated in terms of the testimony of these witnesses.
Right.
Public opinion changed because Court TV covered that preliminary hearing every day. Going into it, 80+% of Court TV viewers thought he was guilty, and coming out of the preliminary hearing, 80+% thought he was not guilty.
And this was a time where, unlike the Michael Jackson and Bill Cosby cases where you didn't encourage the press, you encouraged the press in the Blake case, right?
I did, because, again, I was going to pursue a very unconventional strategy, and I didn't think they were going to be ready for it. And all their main witnesses were put on the stand. Their experts were on the stand. I had a field day with them, and it changed public opinion. And also, I'll tell you, two very good prosecutors left the case because of that preliminary hearing, and a prosecutor replaced him who I don't think was really, as good as the other two.
When you say left, what do you mean left? Like they decided to take themselves off the case, or they were removed?
Well, I don't know internally who made what decision, but I know that two very good prosecutors suddenly left the case.
Interesting.
And a less competent one replaced them. And also, at the preliminary hearing, there was a co-defendant. And based on the preliminary hearing transcript, the co-defendant and the conspiracy count were thrown out. So you've got Blake on bail. You've got the co-defendant and the conspiracy count gone. You've got
the easier charges to prove. Conspiracy is always going to be easier.
Yeah. You've got their witnesses destroyed on videotape. Public opinion has changed. Blake has bail, which makes it much easier to prepare for a trial. And also, when someone's on bond, as you know, seeing them walk in and out of the courthouse seems far less threatening than if they don't have bond.
Sure.
So it was really a great victory for Robert Blake, and it really gave me a national presence, which I hadn't had before. I had a local presence, but not a national presence. You mentioned Michael Jackson. The Jackson people started calling me before the Blake trial, and I turned down the case because I was getting ready for the Blake homicide trial, and they couldn't believe anybody would say no to that, and I did. But then what happened was, in the middle of jury selection, Robert and I had a falling out that will remain confidential.
Sure.
And I withdrew from the case. And not long after I'd withdrawn from the case, the Jackson people came knocking again. Randy Jackson, his brother, called me up and said, "Is there any way you're free? Because we've always wanted you in this case. We don't like our current counsel." And one thing led to another. I ended up on a plane, a secret meeting with Michael Jackson in Orlando, Florida.
What was that like? What was it like to, now you have this incredible opportunity. It falls at your, doorstep. You couldn't take advantage of it before, but now you can. Next thing you know, you find yourself on a plane with Michael Jackson, perhaps the most famous person on the planet.
Well,
what was that like?
It was all very surreal because it was highly confidential. A chauffeur met me at the airport, took me somewhere. I didn't know where we were going. Michael was renting a mansion on a body of water in Orlando. It was all top secret. Randy Jackson, his brother, who wanted me in the case, met me there. I ended up being grilled about my background, my experiences, my perspective on a criminal case, etc., by a small group of people in a room with Michael sitting in the back and saying nothing. He just sat there and stared at me very intently. He had a very, very deep look in his eye, very penetrating stare, and seemed to be just judging everything about me while the others asked the questions. And when I left, I just said to myself, he's probably interviewing a bunch of other people. I mean, who knows what's going to happen? Who knows what he thinks of who I am or what I've done? And I got a call about a week later from Randy saying, Michael wants to hire you. He said after it, he didn't want to interview anybody else, and would you consider doing it? And, of course, I accepted, and one thing led to another.
Might be the strangest job interview I've ever heard of. You got the gig, though. You got the gig.
In celebrity cases, truth is sometimes stranger than fiction, what goes on. So.
I can only imagine. So, by the way, you had a relationship with Randy Jackson. How did you develop that? It seems like, kind of a random thing.
We met through a mutual friend a few years before, and we used to get together every once in a while, and have dinner, and we just liked to joke around and get together once in a while. So I would call him or he would call me. We'd have dinner. These dinners did not involve any expectations of anything, but Randy told me that he watched my performance in the Robert Blake preliminary hearing, and he had his family watch it, and he said, because of that and because of other things you've won that I know about because we're friends, we want you as Michael's lead counsel. So that had a lot to do with my career, I'll tell you that.
So perhaps he was a vote of confidence behind the scenes too. But no doubt when you got in the room, clearly there was his own observations that Michael Jackson was making with you. Do you have any idea who the people were who were questioning you, or just part of his team?
Oh, I do. He had a few confidants. I won't mention who they are. One of them was his nanny, who he had great faith in. He wanted her to study me and make a recommendation. But Randy was the one that really wanted me more than anybody. And you can imagine the competition to get in a case like that. Lawyers are constantly, presenting themselves, trying to solicit the case, backstabbing other people. I mean, from the time I got in that case till verdict day, I kept hearing about lawyers trying to get to Michael Jackson, trying to replace me. And lawyers being very critical of anything I said or did. And unfortunately, lawyers will perceive these kinds of cases as pathways to fame and fortune, and they may or may not be. I've always said these big cases can bring you sky high, or they could bring you to the pit of hell.
There's no doubt. There's no doubt about it. It's a sad story told oftentimes. In fact, I had F. Lee Bailey on my show talking about the O.J. Simpson trial, and his career went straight down after O.J. Simpson, did not go up, and a lot of that had to do with bickering between attorneys. And it's a sad story, it is.
Yeah, I certainly followed that case very closely. Johnnie Cochran recommended me to the Jacksons as well as Randy, and I'll always be indebted to Johnnie for doing that because Johnnie was the greatest trial lawyer I ever watched.
Wow.
Johnnie had a presence, an intuition, an instinct, an intellect, experience. I mean, he was a legend in criminal and civil court in Los Angeles. I mean, he was the first black lawyer in Los Angeles to start taking on the police department and other local agencies and winning big verdicts.
Civil rights cases or defense?
Civil rights. He was the plaintiff's lawyer, highly successful, first African-American lawyer to do this in L.A. so successfully, and then a legendary criminal defense lawyer. Who won acquittal after acquittal in murder cases, white-collar cases, you name it. And I studied Johnnie every way I could, particularly watching the O.J. Simpson trial, and I've never seen a closing argument quite like that. I would recommend to anyone who wants to be a trial lawyer, watch Johnnie Cochran's closing argument in the O.J. Simpson case. It's just a remarkable tour de force. It's just, in fact, I'll never forget, in the middle of his closing argument, during a break in the trial proceedings, the camera goes back to New York for a panel of experts at Court TV. One of them is the district attorney of Brooklyn. I think there may have been a professor or two and some seasoned trial lawyers. And I remember the district attorney in Brooklyn said, you know, I've been teaching at local law schools for decades now, and I always tell my students, you know, in your closing argument, make it short and sweet. Don't bore the jury. That's the worst thing you can do. He said, after what I've just seen, I have to reconsider what I've been teaching. He said, this is absolutely remarkable what I'm watching.
Wow.
You know, that is a fantastic closing argument. But his whole trial performance was amazingly skilled, amazingly flexible, amazingly insightful. He knew exactly what he had to do and how to do it. And he was a good human being as well, you know, who didn't come across as pompous or elitist or looking down on anybody. He came across as a gentle, kind, caring, but very aggressive and skilled lawyer. And I'm repeating myself, he's the best trial lawyer ever watched.
That's amazing. And I think there is a wealth of knowledge to gain from watching some of those clips. And F. Lee Bailey's cross-examination of Mark Furman, too.
That was terrific. That was really
yeah.
Terrific.
There was some wonderful lawyering in that case. But, it was I would love to learn more about Johnnie Cochran and your relationship with him. Did you ever get into a case with him?
No, I never tried a case with him. We always crossed paths. We got awards together, and he always said the nicest things about me. And I'd like to say I was one of his closest friends, but I wasn't, so that would not be truthful. But I always would hear from other people how complimentary he was of me. And I did meet with him right before I went up to Santa Maria, California for the Michael Jackson trial. Just so, you know, in case anyone doesn't know, Santa Maria, where the Michael Jackson trial took place, is in Santa Barbara County, which is north of Los Angeles County, where I practice. And as I was about to move up there, and I lived up there for 6 months, the trial was 5 months, I visited Johnnie at his home in Los Angeles. And he wasn't telling people much about his terminal cancer, but he had a brain tumor that was inoperable. It was malignant. And I met him in his living room. He had an aluminum cane that was holding him up because his balance was affected. He'd lost a lot of weight. But
how old was he at that point, Tom?
He was about 68.
That's sad.
He'd lost a lot of weight. He was still optimistic, planning a trip to New York, felt he was going to beat this. And that was the last time I saw him until the funeral, which happened in the middle of the Michael Jackson trial. And Michael and I went to the funeral.
Wow. I'm going to stop for a second, just if it's okay with you.
Sure.
I'm enjoying your stories too much to cut you off or to change subjects. So I'd like to, if it's okay with you, maybe we can continue with the Michael Jackson trial and explore the other things we're going to discuss on another phone call.
Whatever you'd like, sure.
Okay, great. So let's just keep rolling. I'm having a great time listening. You have so many stories, and I'm fascinated by your career. So why would Michael Jackson go to Johnnie Cochran's funeral? Did they have a relationship?
They did. Johnnie had been his lawyer when a prior molestation allegation was made in 1993. And Johnnie had been representing him along with Howard Weitzman and some other lawyers, and they settled that case for a reported $20 million.
That settlement, why was there no criminal charges back then?
You know, I can't tell you why. Michael was investigated by the Los Angeles County District Attorney's Office and the Santa Barbara County District Attorney's Office. After the Michael Jackson acquittals, I was asked to speak to the Grand Jury Association of California, which was meeting in Los Angeles County. And after my talk and after the lunch, one of the members came up and told me that she was in the grand jury in Los Angeles that conducted an investigation into these allegations, and she said, we thought the witnesses were very flaky. Something seemed wrong with this particular line of thought, and, we didn't indict them for anything. At the same time, you had, as I said before, a grand jury investigation in Santa Barbara County, which is north of Los Angeles County,
Right, with
and they didn't indict them either. I wasn't in those, grand jury rooms. I looked at transcripts, and I've always said that, these allegations against Michael, while voluminous, were very flaky and unreliable. And
so those were presented. Those 1983 cases were presented.
That's my understanding.
That's very interesting. I did not know that.
Now, just in answer to your question, the former district attorney of Santa Barbara County, who I went up against in the Michael Jackson trial, is now deceased. His name was Tom Sneddon.
Mm-hmm.
He claimed these were investigatory grand juries, and not, that no charges were actually presented. I never quite bought that.
Yeah, that sounds very peculiar, especially for someone like Michael Jackson.
Yeah, I never really bought that explanation, but that's what the district attorney's office was saying, that these were simply investigative. They were not convened for the purpose of bringing a charge. You can take that however you want. I didn't quite believe it.
So maybe about 20 years later is when this new charge comes against Michael Jackson. And
not 20. This was 1994. 1993, 94 was the first allegation, and the allegation that I represented him in came out about 2003, 2004.
Okay, so the timeline's not that far apart, but still, far apart enough. And they end up indicting Michael Jackson, and he's going to have the trial. He has an attorney before you.
Well, here's what happened. First, they filed a criminal complaint. And at that point, Michael Jackson was being represented by Mark Garagos in Los Angeles and Ben Brafman from New York. Before they had any preliminary hearing, which Michael had a right to because a criminal complaint had been filed, they dismissed the criminal complaint and went by way of grand jury. So it started with a criminal complaint. And rather than have a preliminary hearing, the district attorney then decided they didn't want a preliminary hearing, so they conducted a secret grand jury investigation, and they indicted him by way of grand jury.
So a direct indictment instead of the preliminary hearing, so you didn't have the same opportunity you did in the Blake case. Would you have done the same thing, or you think you would have played this one differently?
That's a good question. It would depend on who they produced, because in the Blake preliminary hearing, even though they had a right to put a cop on to just give hearsay testimony as to what witnesses would say, they elected for the most part to go along with the live witnesses. Mm-hmm. Now, if they had done that in the Michael Jackson case in a preliminary hearing, I might have gone after them. But they decided they didn't want any preliminary hearing, and that's why they switched course from a criminal complaint to a grand jury investigation and indictment. I may have done the same thing, and I think the Michael Jackson people were hoping I would do the same thing.
So it ended up being a different kind of procedure. The indictment comes down, you get in the case. The attorney before you had a much different approach to the media and in general with the defense. How did you approach this differently when you got in the case?
I approached it very differently. I basically said to Michael and his family that the public relations that I'm watching are terrible. This is a very conservative, largely white, blue-collar community, to a lesser extent Latino. I said there are hardly any African Americans in this jury pool, and you're showing up with the Nation of Islam for every court appearance surrounding you. You've got black activists, appearing at the courthouse, screaming it's a racist prosecution. You've got your father saying it's illegal lynching. Your brother Jermaine is going on TV saying it's illegal lynching. I said, this is not going to appeal to the jury pool that you have to pick from. And I
How
said,
did he feel? How did he feel then?
he listened, because Michael is not a lawyer. Michael doesn't know the criminal justice system. He's going to whoever he thinks will protect him.
Mm-hmm.
I said, I don't want the Nation of Islam to be visibly, protecting you and surrounding you. I said, they're disconnecting you from the community that's going to judge your fate. And you need to align more with the community you live in, because what I learned was, he employed about 90 to 100 people at Neverland Ranch and had a very good reputation, in that community.
Right.
People didn't see him that often, but when they saw him, they liked him. He was thought to be very kind and nice. And I said, by turning this into what looks like a racial issue to a lot of white people, you're going to disconnect yourself from your community that's going to judge your fate.
That's a great point.
So I said, this is a terrible mistake. And that was the first thing I did. And I said, I don't want, your family calling it a legal lynching. It is, but I don't want them saying it because I know how it's going to be misinterpreted by a lot of the white jury pool. So he listened to me, and I said, we're not going to make this a racial issue. And I also wanted him to make a public statement where he embraced his community. He said, this is my community. This is where I chose to live. This is where my children have been raised.
Did he do that?
We did it, yeah.
He did it, but through you, I'm assuming.
I certainly helped out, but he made the statement. We got permission to make it. There was
that's kind of what I was wondering, is how can you make any statement during the pending
Well, this is a very interesting issue because I've never seen a trial judge handle publicity or public relations or the media quite the way this judge did. And he did a very good job at doing it. What this judge did was he had a gag order. The gag order basically said you cannot talk about the facts of the case publicly. Mm-hmm. He said you can talk about procedure. If a member of the media calls you and says there's a hearing on a motion, what is this about? You can very antiseptically and objectively explain the procedure, but you cannot talk about the facts of the case. And he said also, I'm going to put into effect a unique procedure for handling motions. Because typically when there's a gag order in a case, people start talking to the media through their motions. They file documents with the court that the media can read. He said, if you file a motion, that means you're going to have to file 3 motions. 1, I'm going to set out some standards to keep inflammatory material from the media. You're going to file a redacted motion based on my standards. And you're going to keep inflammatory material out of the motion. You're going to redact it. You're going to keep inflammatory arguments out of the motion. You're going to redact it. That will be the public motion. You will also file the complete motion unredacted under seal. And thirdly, you will file a motion to seal that document. And that's the way we proceeded. And I thought it was a great way to go. I did not want cameras in the courtroom. The prior lawyers had appealed the judge's gag order because they wanted cameras in the courtroom, or at least Mr. Garagos did. I dismissed that appeal. I did not want cameras in the courtroom for the Jackson case. As we discussed earlier, I did want them in for the Robert Blake case. I thought we would benefit because I really intended to surprise them. And I thought it would just work to our benefit, which it did. But in the Jackson case, I didn't want witnesses watching what other witnesses said on TV. I did want witnesses watching commentary what other witnesses were saying on TV. I felt it would not work to our benefit. And, obviously things worked out well. We got 14 not guilty verdicts, 10 felonies, 4 misdemeanors, no convictions, so it worked. But that was my approach to the Michael Jackson case when it came to media and public relations.
It's really worth discussing a little bit because it's remarkable how much strategy and how much impact these types of decisions can make. Let me give you an example. I just read the prosecutor in the Casey Anthony's book, and Jose Baez, the defense attorney in that case, he would file motions at 4:25 on a Friday with the intention that the media would get a copy of the motions, advance his theory on the front pages through the weekend before the judge or the prosecutor even read it. Mm-hmm. And it heavily impacted, in the prosecutor's opinion, the presentation of the case. And, it's just an interesting, you don't really understand that unless you're in this type of practice, how much it can impact the fair play in the courtroom, what goes on outside of the courtroom.
Well, let me say this. I do think a lot of lawyers overestimate the effect of media on a trial. I firmly believe cases, even high-profile cases, are won or lost in the courtroom. That doesn't mean you don't want good public relations. Of course you do. Mm-hmm. But if you get too carried away with public relations and too carried away with, how you're appearing in the media, lawyers start to think the case is about them and not about the clients.
Right.
And you have to always keep in mind that the most important people are 13 people, 12 jurors and a judge. Mm-hmm. They are the most important people that you have to address, not, the evening talk shows. Yes, I do think good PR is important. If you can get it, you want to do it. But I think primarily these cases are won in the courtroom, and you never can forget that.
Yeah, I think maybe you might miss things too. If you're not focusing on the courtroom, you might miss things or opportunities. But I think there's different strategies for each way. I agree with you. Another strategy that you brought in this case was to bring in Macaulay Culkin and another child who had exposure to Mr. Jackson to bring in defense of your case. And the prosecutor seemed to never even really grasp that, even up until when you put them on the stand. Is that true?
Well, yeah. There was, towards the end of the prosecution's case, I talked with Mr. Snedden one day, and he wanted to know who we were going to start our case with. And I told him we were starting with 3 of the so-called victims that he had called witnesses to say were molested. And I told him, I said, they're going to say they were not molested.
How did you know that?
We had interviewed them.
You interviewed them by way of private investigators?
Yeah.
Okay.
And, after the investigators, confirmed what they were going to say, of course, we subpoenaed them, and we really didn't have to subpoena them because they were going to come anyway. Mm-hmm. And these 3 young men all said, he never touched me. He's my friend. I travel with him. He never touched me. Now, the prosecution had called witnesses to say they watched them being molested. It's kind of strange. Now, let me say this about our case. When the prosecution rested, I had to think very carefully, do we want to put on a defense? Because I felt we would hang the jury with our cross-examination.
Oh, that's interesting.
And I felt 99% of criminal defense attorneys in my position, particularly in a situation where nobody thought they had a chance, would probably rest. And I came to the conclusion that we'd probably get a hung jury. I wasn't confident he'd be acquitted on every count, but I didn't think he'd be convicted. But I also thought, I don't think Michael Jackson can survive a retrial. Physically, emotionally. He's handling this, so badly. If you look at him, he's just losing weight. He's just deteriorating. And I felt we had a good story to tell, even though you always want to risk when you put on a defense because every witness is going to be subjected to cross-examination.
Sure.
Now, it started with these 3 young men, and, of course, on cross-examination, they admitted they would sleep in his bed, they would travel with him, sleep in his bed, and they said nothing improper ever happened. We were just friends. Now, I was criticized by some people in the media for putting on a case, particularly allowing the prosecution to bring out this kind of evidence. But I had a long-term strategy in mind, and I felt this, to get an acquittal on everything, we really had to tell our story and withstand the hits on cross-examination because I was trying to show that Michael was someone who had no childhood. He was raised in Gary, Indiana, at nine people in a 2-room house. The family discovered this child was a prodigy, a genius at a very early age. And, when he was 3-4 years old, he was rehearsing till 3 a.m. He was performing at clubs, seedy strip clubs in Chicago and Detroit on weekends. He never had a chance to have a real childhood. He said that he walked out of a a club one day. It was the early morning hours. I think it was in Detroit. He saw kids playing in a schoolyard, and he wanted to be one of them, and he couldn't. So I had to explain that he basically never had a childhood. He was forced to perform and rehearse from a very early age, was very strictly disciplined. It developed his talent, but it hurt him emotionally. And I said there was no sexual interest in kids. There was just an interest in being a child. I mean, he built Neverland. It had an amusement park. It had rides. It had a zoo. You know, he was trying to recapture a childhood he never had. So I had to explain all that, and I decided even though you're going to take some hits doing it, we have to put on a defense case. We have to take our chance. Unfortunately, it worked.
So how do you tell that? First of all, did you open on that? Did you tell the jury that you were going to paint that picture? And then second of all, how do you tell that story? I mean, bringing in the kids can explain a little bit, but the rest of it seems like you would need to put Michael on, or at least somebody who has a relationship closer than that.
Well, that's an interesting question. First of all, my strategy in opening statement is to be very aggressive. I think opening statement, even though they say it's not argument, it is argument.
Sure.
There's a convention that says opening statement is a statement of what you intend to show or prove. It's not an argument. Well, I think it is an argument in one form or another. And I'm not the kind of person that likes to rely on reasonable doubt or presumption of innocence at the beginning of a trial. So I think jurors want to know the truth. I think they think the lawyers know the truth, whether they do or they don't. And I think that the worst thing a defense lawyer can do is get up and talk about the presumption of innocence, talk about the burden of proof, talk about reasonable doubt. In my mind, when jurors start hearing this, their thought process is, you know, this guy is using technicalities to try and make sure the prosecution can't prove their case. I suspect his client's guilty, but maybe he thinks he can avoid proving it by stressing technicality. So I get up and I tell them I'm going to prove this and I'm going to prove that, and I never mention reasonable doubt. And I don't mention presumption of innocence. I want to come across as the bearer of truth. And so I gave a very aggressive opening statement that I would prove the man was innocent, that I would prove all sorts of things. And I'll tell you later on if you want about the closing arguments. There's a funny story about all this, but I came out as the bearer of truth. I said we have nothing to hide, nothing to be afraid of, and here's what I'm going to prove, A, B, C, D, and E, and I'm going to prove that this man didn't have a child. I'm going to prove this and prove that. But as far as putting him on the stand, I told them they would hear from Michael Jackson. I didn't. You did say that.
Oh, okay.
I said you'll hear from him, and did I know they were going to hear from him? Of course I did, because the prosecution, over defense objection, although secretly I wanted what I was objecting to, they intended to bring in the infamous Bashir documentary. I don't know if you remember that, but a British journalist named Martin Bashir had done a documentary on Michael Jackson. And he convinced Michael Jackson it would be a very positive, expose on who he is and how he's lived his life and, how he approaches his art and his craft and the world, et cetera. And it turned out to be sort of a scandal piece. This guy, in my opinion, misled Michael Jackson and wanted it to be sort of scandalous. And there was this one quote where Michael Jackson says words to the effect, "There's nothing nicer than to share your bed with someone, but nothing sexual goes on. I sleep on the floor, blah, blah." Or at least in one instance with the main accuser in the case, he said he slept on the floor. But at any rate, Michael Jackson was savvy enough. Unfortunately, he was not savvy enough to reject this man's request to do a documentary. He was savvy enough to have his own videographer at all the interviews. So we had all the outtakes that this guy removed from his documentary.
Did the prosecution have the outtakes?
They did, and they asked the court for permission to play the documentary, even though it was edited hearsay, and then objected to our wanting to counter it by bringing in the outtakes. And the judge basically said, if you're going to play that documentary, the defense can use the outtakes. Well, in the outtakes,
makes sense.
Michael Jackson says I never would sexually touch a child. I would slit my wrist before I would do it. He basically answers all the questions that he would have been asked on direct in a uncross-examinable case. So they put on the Bashir documentary. I put on the outtakes and all of his denials and explanations, and I never had to put them on.
Did you do it at the was the documentary played and then you played the outtakes directly afterward, or did you reserve that for your defense?
That was for the defense.
Okay, so there's some time between the video playing the first time and the second. That's so interesting. It's really,
but even the video, you know what happened, I think? I thought the video was going to help us because I thought the media was focusing on these few words they said would damn Michael. And I looked at it, and you see him as a child dancing and singing. You see how innocent and naive he is while this journalist is questioning him. The music is infectious. He comes across as a very nice person. And I felt that documentary plus the outtakes would help us humanize him in a very, very profound way, and I think it did.
That's so interesting. And it's such an unorthodox way of a trial, bringing in the defense's side. But, it paints the picture, I guess, right?
Well, listen, in the Robert Blake trial, the prosecution in L.A. County made the same mistake. Barbara Walters had done an interview with Robert Blake in Los Angeles County Jail, which I didn't want him to do. Oh, and she asked him all these questions about the case, and he, just in a very passionate, emotional way, professed his innocence. And the prosecutor brought in a sliver of that interview to show the jury that he lacked credibility. She was saying it contradicted a secretly recorded statement he made with a friend, which was not privileged. And in so doing, she opened the whole door to the interview. So the defense played that interview, and he's professing his innocence, and he didn't have to testify either.
Interesting.
I've seen prosecutors sometimes get so wound up with their presentation in their case that they don't really imagine what the defense is going to counter it with.
Right.
They get so caught up in their mission and their zealous belief that they're in the right that I don't think they think very creatively about what the defense might do in response.
That's so interesting. So we've talked a little bit about the Michael Jackson case, but we really haven't explained what the charges were entirely. Can you give a nutshell version of what the charges were against Michael?
They were pretty horrendous. They charged him with conspiracy to abduct children, to extort, and to falsely imprison a family. They charged him with counts of child molestation, attempted child molestation, and then 4 felony counts of plying a cancer-stricken child with alcohol to prepare that child to be molested.
And factually, this was all stemming from a young child who had cancer, whom Michael brought in, heard about him from the community, brought him in to try and befriend him, and it all kind of backfired, orchestrated by his mother.
Well, Michael, became friendly with the family. He was told his child was suffering from terminal cancer and wanted to meet him. And Michael met the whole family. He put them up at Neverland Ranch on a number of occasions, the whole family. He had a blood drive for them. He bought them various things, computers, whatever, was very kind to them. And from our point of view, at some point, Michael decided that, he wanted to distance himself from the family. And they got very upset, in my opinion, at the way he was treating them at that point. And they claimed they were falsely imprisoned at Neverland. I think I proved it just was implausible that that happened because they kept going back. And to make a long story short, these horrible allegations were made that he falsely imprisoned them, that he extorted them, that he molested the alleged victim. And I thought we countered everything pretty well. But the prosecution had a very diabolical strategy, in my opinion, that your lawyer listeners might be interested in. I mentioned the conspiracy charge, which I thought was absurd. The idea of Michael Jackson masterminding a conspiracy to falsely imprison a family and abduct children and commit a criminal extortion was just ridiculous. But here's what the prosecution did, in my opinion. trial lawyers know that in a conspiracy case, co-conspirator hearsay statements are admissible. Mm-hmm. That there's a general prohibition on hearsay, which is an out-of-court statement that can't be cross-examined coming in. But there's an exception made when a conspiracy is alleged.
Right.
And what they did in this case was they alleged a conspiracy, but the only one indicted as a member of the conspiracy was Michael Jackson. They were calling other people who were at Neverland Ranch at the time unindicted co-conspirators. And what that meant was their witnesses could bring in uncross-examinable hearsay statements from other alleged co-conspirators, and we couldn't bring those alleged co-conspirators in because they were so scared they'd be charged that they went to lawyers who all said, don't say anything, don't testify. So it was an attempt to make him look very evil. It was an attempt to bring in hearsay that normally wouldn't be admissible, and it was an attempt to discourage witnesses from coming in to help us. That's how I look at their strategy. I thought it was pretty diabolical, and I'm sure some of your lawyer listeners will have, you could have a nice discussion with them about that. But that's what I think they did.
Yeah, that's interesting. It brings up evidentiary issues too, I think. I don't know how many times I've even heard of a co-conspirator not being indicted and only one and hearsay evidence being brought in. Strange, very strange. But
they would file pleadings, and one pleading would mention a number of alleged unindicted co-conspirators, and then as they got closer to trial, they would mention more names. And I'm convinced the reason they did that was to scare them away from testifying for Michael Jackson, to scare them away from coming in and refuting what their witnesses were going to say they said and did.
Did you tell the jury, you're going to hear about these co-conspirators, but where are they? Why aren't they here? Why weren't they charged? What, is this whole thing's baloney? Did you bring that up, or was that not really part of the threat?
I didn't bring that up in opening, as I recall. I did mock the conspiracy charge in my closing. And I said, look, if they lack so much credibility that they would bring a ridiculous case like this, what does it tell you about everything else?
Right. Poking some huge holes.
Yeah.
So we've been at this for about an hour. I don't want to take up your whole day. What I'm thinking is maybe we can pick up on another call and talk about your closing, your great story in closing, and finish up the Michael Jackson case and transition to the Cosby case. Is that okay with you?
I'd be honored to. Sure. Thank you very much for thinking of me.
Well, that's great. Thanks, Tom. I have what we do on the show is we have 5 questions for each guest. I do want to ask you those questions now, and maybe I'll even ask them again next time. But are you ready to go in our under oath 5 questions?
Am I under oath?
You're under oath, my friend.
I assert my Fifth Amendment privilege.
Overruled. All right. So the first question is, what case are you most proud of in your career and why? And we can tap on this more next time as well. Well,
I want to make clear that to anyone charged with a crime, their case is the most important case. And I don't value one life over another life. I've defended homeless people. I've defended the greatest celebrity of my lifetime, Michael Jackson. And all lives have equal value. And I don't judge one life as more valuable than the others.
That's great. Well said.
I'm very proud of a lot of cases I tried. I went down to Alabama 20 years ago and agreed to defend a homeless black man who was charged with murdering a beautiful white girl from a prominent family. And
that's the Bonner case?
That's the Terry Bonner case, and we acquitted him. My co-counsels, Charlie Salvaggio, Wilson Myers, and I acquitted him. And I'm very proud of that case. This was a homeless man that I felt they tried to pin a high-profile murder on. And,
a beauty queen, right? Or she was, we'll talk about that probably next time, but it's really, it's a fascinating case.
I'm very proud of that. I'm also proud of the Michael Jackson case. A lot of my colleagues told me not to take it, that it would destroy my career, that you couldn't win it, and the rest of your life, anyone who ever saw you anywhere in the world will say that's the guy who sent Michael Jackson to prison.
Or you could also be the guy who turned down the Michael Jackson case. So I would strongly disagree with those guys.
Well, they were telling me that, I think in good faith, that you can't win it. You're just going to be categorized the rest of your life as the one who lost the Michael Jackson case. And I just said, look, this is what I do.
Yeah, this is what we're built for.
I'm a criminal defense attorney, and I don't just shy away from the rough ones. So,
right.
that case had more media than any case in history. I mean, you had over 2,200 accredited media, more than O.J. Simpson and Scott Peterson combined.
Wow.
So that had unique pressures. I'm very proud of the way it was handled. But I'm also proud of other clients who've had no resources and were innocent, and I was able to acquit them. I'm very, and I'm honored to defend people and make our Constitution work. I don't care what people think of what we criminal defense lawyers do, whether they like us or don't like us. I think we've done more to create and preserve freedom in American history than any other group of professionals I can think of.
John Adams.
Yes, and absolutely. John Adams, was going to be president not long afterwards, I believe. And John Adams was a lawyer in Boston, and during the infamous Boston Massacre, he saw all these young British soldiers rounded up and charged with murder, and he said, wait a second, they're not all guilty of murder, and he agreed to defend them pro bono and acquitted a good number of them.
Sure.
That's what I think we're built to do, and every time we walk into a trial and we're prepared and we're aggressive, we make the legal system work and protect freedom and protect liberty, I think our country's better, and I think it's a great thing we do.
I agree with you 100%. If you could, I'm really curious about this one because I have two people in mind. I'm not sure who you're going to pick, but if you could try a case with one person, dead or alive, who would it be?
With one lawyer, you mean?
With one lawyer. With one lawyer. Let's narrow it down. I don't want you to have the history of the world to think about it. Let's do an American lawyer. One American lawyer.
It would be Johnnie Cochran, the greatest lawyer I ever saw. But I also want to tell you that there are many lawyers I studied who I never saw, like Earl Rogers 100 years ago was the most famous criminal defense lawyer in Los Angeles and a fascinating man to study. My favorite book about a criminal defense lawyer was written by his daughter. It's called Final Verdict by Adele Rogers St. John. And
Primal Verdict, you said? Primal Verdict?
It's called Final.
Oh, Final Verdict. Okay.
Final
all right, I'll look it
Verdict
up.
By Adele Rogers St. John, and also Clarence Darrow. I mean, I've
That's
studied
what I figured.
him.
I know he's your guy. That's why I figured you might say him. And he's a frequent flyer on my guest list.
I've studied him backwards and forwards, and every year I try to read a book either by him or about him, because his ability to bring compassion and humanity and kindness and decency, as well as the towering intellect into the courtroom was really phenomenal. I don't know if you read any of his closing arguments. They're just phenomenal.
The Leopold and Loeb one is my favorite.
Well, the one in the Sweet case is terrific, too.
I'll have to take a look at that one.
FWEET, the Sweet case, is phenomenal. It took place in Detroit in the early 1920s.
I will check that out. And while you're reading Darrow books, if you get a chance, read Worse Than the Devil, which is by Dean Strang, who was on our show. He wrote a book that involved Darrow representing some people in the Midwest. Really interesting.
Okay.
I'll send it to you. I'll send you a copy.
Oh, terrific. Thank you.
My next question is, what book has inspired you and what movie has inspired you? It does not have to be law-related.
What book has inspired me? A book of Clarence Darrow's closing arguments that was it was edited and published by a couple named Weinberg is phenomenal. I've read it and read it and read it again. And frankly, every night in the Michael Jackson trial, I would try to read a little bit from that book before I went to bed.
Wow, that's really interesting.
Very inspiring. Huh. You say, what movie?
Yeah, a movie that's inspired you. Doesn't have to be law-related.
What movie has inspired me? Boy, that's... well, To Kill a Mockingbird, of course, is a fabulous film.
Yeah.
The movie and the book. So I'd have to say that.
Atticus Finch.
Yes.
What a good trial lawyer? Well, let me ask it a different way. A great trial lawyer should never do this.
Never condescend to anybody.
Okay.
You can be righteously indignant. You can be righteously upset. Never condescend to anyone, especially a jury. They're smarter than you are.
Yes, that's a great word of advice. A trial lawyer should do this every day.
Try to learn something about their client that helps you humanize them in the courtroom.
Oh, boy. You're not kidding. You're not kidding. And that's for a criminal defense lawyer. It might not be bad for every area of law, frankly.
Sure.
Tom, you have been under oath. My baby's crying in the background. You know I'm on daddy duty right now, so I'll finish up with him, and maybe we can catch up on this next week or soon and get back to the Jackson trial.
I'd love to. Thank you very much. I really enjoyed it, and I'm very honored you invited me.
Thanks so much, Tom. We'll talk soon.
Thanks.
Take care.
Well, that was our interview with Tom Mesereau. These interviews, sometimes I do them by phone, sometimes I do them by Skype. That one was by phone, and the quality went in and out, and I apologize for that, but the content was spectacular. I had a great time interviewing him, and I can't wait for the next time. We've already set up our scheduled call or Skype or whatever it may be, but we'll get into the Cosby Show then. I hope for this episode you enjoyed his discussion on the Michael Jackson and Robert Blake case. He clearly has a different approach to lawyering than many other people, a little bit more on edge, a little unorthodox, and I think it's done him well in the courtroom, and it certainly has led to success for him in the past. The Michael Jackson case was an easily losable case. In fact, it was probably headed in the wrong direction before Tom got involved in the case and rescued it. Sex assaults and molestation cases in general are usually a he said, she said battle, but oftentimes there is no hard evidence. And really, it's a test between the accuser and the defendant. Those cases truly are affected dramatically by the lawyer and the style that they bring into the case. As Tom Mesereau points out often in his interviews, lawyering is an art and not a science. So the style that the lawyer brings in and their way of trying cases is instrumental in the defense of that type of action. So it was really nice to have Tom on the show to bring us into his world and how he approached the Michael Jackson case. And how cool is it to hear about him being on, a secret flight, going with secret bodyguards to a secret location on a secret island in Florida, where he gets interviewed with Michael Jackson in the back of the room, staring at him the whole time and judging him. I mean, it's just wild. This is stuff that you probably wouldn't believe if you saw it in the movies, but it's true, and it was cool to get inside that world. We thank him very much, and we'll see him back soon on the show. As always, I'd like to thank some people who are supportive of our podcast. I want to thank Sean Penna, another Bergen Catholic graduate and a wonderful lawyer who I've had cases with in the past. Tom Horahan, Cassie and Kellen Murphy, and you, whoever's listening to this podcast. You made it to the end of this episode. Now go tell a friend, go tell your family, post something on Facebook or Twitter. That's how we get our word out. That's how we get new listeners. And it's been a wonderful time doing this interview, and we look forward to the next one on Under Oath.
We hope you enjoyed this episode of Under Oath. Please join us on the next episode for another look inside America's most famous cases with the people who tried them. To find out more or to see a video and pictures from each episode, go to underoathpodcast.com. You can follow us on Twitter at UnderOathPC. Today's episode was brought to you by the Lomurro Law Firm. Production of today's podcast was done by Jersey Shore Reporting. Tune in next time and find out who will be put under oath.